Hey everyone, this is Shinju. We're here for day 2 of Macros 2021. We have Kyle here who will be doing a talk on a deep dive on crypto, privacy, and financial crime. And I'll let her introduce herself and take it from here. And thank you guys so much for showing up and appreciate all of our community partners for all the support. Thanks.
Hi there. Thanks so much for the introduction. I'm hearing a little bit of echo. I don't know where that is coming from.
I don't hear it on my end.
Oh, you don't?
But if you want, you can refresh your browser so you don't hear it, or you can use a mic.
If you don't hear it, I'll just proceed.
Sounds good.
All right. Thanks so much for being here. My name is Kyle Freeney. I am a partner in the law firm of Greenberg Traurig in Washington, D.C. And I focus my practice on helping companies navigate civil, criminal, and regulatory enforcement actions with a particular focus on anti-money laundering and financial crime. But prior to joining the law firm, I was with the Department of Justice for about 12 years. And recently, up until about a year ago, I was money laundering prosecutor with DOJ. And so the aim of this presentation is to just give a little bit of a perspective on what the government is looking at in terms of privacy, cryptocurrency, and financial crime. Now, I could say I am not, or speak on behalf of the government. I am not with the government. That actually gives me a little bit more leeway to give some candid reflections of, from what I've seen now that I am in the private sector. This is not going to be a normative presentation. That is like the way that it should be. It's really going to be, the aim is to present the way things are. And then the last caveat, because I'm a lawyer, and so we always give a lot of caveats. This is not going to be particularly technical. I am not a digital native. I had an Etch-a-Sketch when I was a little kid. So I know the amount of text I need to know to, interface with my clients and kind of bridge that gap between tech and law, but I'm not a technical expert. And so I'm going to just apologize in advance if I use the wrong terms. And then in some senses, it's not going to be particularly complicated technically because the Department of Justice and other law enforcement agencies really are not highly technical. They're really fine. So if you think, oh, wow, this is so 2017, well, the government these days is probably kind of 2015. And so in that sense, that's where they are. So we're leaving them where they are. To the extent that this presentation is informed by my perspective as a former DOJ prosecutor, I thought I would give a little bit of color to where that came from. This is one example, but it is a significant matter that I worked on when I was in the Department of Justice. So I was a prosecutor with the Special Counsel's Office, that is on the investigation led by Robert Mueller into the foreign interference with U.S. elections. And so I obviously cannot speak about internal things about that matter. So what I'm going to do is just show a little bit of the public indictment that was issued in connection with that investigation, because this sort of informs where I was coming from in terms of perspective on cryptocurrency and law enforcement investigations. So in July of 2018, the Department of Justice issued an indictment against several Russian intelligence officers for, among other things, computer hacking, into computer intrusions, but also a count of money laundering. And you can see I've just cut and pasted the text of the indictment on this screen. And the allegation was that to facilitate the purchase of infrastructure used in a hacking activity, that including hacking of the computers of U.S. persons and entities involved in the election, and the release of stolen documents, the defendants conspired to launder the equivalent of more than $95,000 through a web of transactions structured to capitalize on the perceived anonymity of cryptocurrencies such as Bitcoin. So, of all the things that we did during the investigation, this was one of the less reported ones, but it is, of course, public. And the idea being the government alleged, it's just an allegation, that Bitcoin was used to facilitate the purchase of infrastructure in the hacking. And interestingly here, of course, you notice the alleges only the perceived anonymity of cryptocurrencies, which folks like you, I'm sure, understand. But the general public, I think, at that time, believed that Bitcoin was in fact anonymous and not just synonymous. And we actually, the indictment alleged a decent amount of granularity.
Hey, Kyle, the audience is saying the sound is a little choppy. Would you mind refreshing your browser? So just click enter on the URL, and it should refresh and kick you back into Crowdcast. Sorry, guys. Can you talk a little more?
Okay. I'm still getting a little bit of an echo, and I'm hearing one from you. But
do you have Crowdcast open on another tab?
Is that better? No. Is that better?
Yeah, I think it'd be good for you to be closer to your laptop as well, if possible.
How about that? Is that better?
Yeah, much better.
Okay.
And if you can share your screen again, that'd be great.
Yeah. All right, guys. So let me know if that does not work. Is that okay? Are we okay now?
Yes.
Okay, perfect. Sorry, guys. I suppose the caveat in the beginning about my not being a digital native was necessary after all. I had some problems getting Crowdcast to work. So let me just jump back in. I was just recounting a little bit about sort of where my perspective on Bitcoin and financial crime comes from, and that is from, among other things, the work that I did at the Justice Department, which included tracing the payment of Bitcoin by Russian intelligence officers, as alleged in the indictment that you see in front of you, to the purchase of various infrastructure. And in the indictment that was issued in July of 2017, the government actually was able to allege a certain degree of granularity in that tracing. So I just put an example here about to show that level of granularity. That is, the government identified a Bitcoin mining operation and then traced funds to the registration for a website that was used to leak the stolen documents. And then also to another address that was used to renew a different domain that also featured in the hacking effort. These are just examples, but when I show this clip of just straight from the indictment, when I show this to a group of lawyers, they're kind of aghast. They're very surprised that the government was able to do that amount of tracing at that level of granularity. I suspect that the folks in this office, being so much more savvy in this space, are not all that surprised. But that may show the disconnect between sort of where law enforcement and the public are and where the technology is. All right. So, in terms of understanding where the federal government's perspective is on cryptocurrency, I think a good place to start is with the DOJ's cryptocurrency enforcement framework. This was issued only a couple months ago in October of 2020. And one would think, well, wow, what was the previous version? There was no previous version. So of course, it took until October 2020 for DOJ to finally, kind of crystallize its actual, a department-wide vantage point on cryptocurrency, where previously it was sort of ad hoc. The document identifies basically 3 categories of illicit use. And these are pretty basic, but I think it's kind of important to conceptualize because it's relevant to like where we care about privacy. So one category are folks engaging in financial transactions that are associated with the commissions of the crime, right? And so that's folks who are buying drugs, child pornography, oftentimes on darknet markets, not always, but very commonly using intermediaries. The second category is folks engaging in money laundering, so moving money back and forth that are the proceeds of crime as a way to hide the source or hide the money from tax authorities. And then the third are crimes that actually are related to the cryptocurrency marketplace itself, like the theft through hacking, or, for example, investor fraud or fraud in initial coin offerings. The first 2 categories are what we really care about when we talk about privacy and the law enforcement community, because those are the 2 categories where, from the perspective of law enforcement, the financial transaction, it's the evidence of the crime, and not just the evidence of the crime, it is the crime itself, right? That purchase of pornography, that is the crime. And so that's where law enforcement is most concerned about the privacy aspects of cryptocurrency and other digital assets. So I wanted to include a little bit about directly from DOJ's cryptocurrency enforcement framework, because it is a fantastic step forward by the federal government. The very first line in that document is innovation can drive a society forward. That is fantastic news for folks in this audience and for everyone trying to use innovation for progress. And prior to this iteration, one might have assumed that the Department of Justice thought cryptocurrency was pretty much always a sign of money laundering or criminal activity. I mean, I would say before, in the last couple of years, maybe 4 years ago, it was probably fair to say that there were 2 categories of folks, generally speaking, within the federal law enforcement community: those who didn't know what cryptocurrency was, and those who really did think anyone who uses cryptocurrency is a criminal. So this is a huge step forward. This is the Department of Justice saying, you know what? I mean, probably reluctantly, we know this is where things are going, and so we're gonna, we know we have to move along, and this cryptocurrency and blockchain technology can be a force for good. So that's fantastic. You see on the right side, that's a quote. That's a recognition, though, but the technology does play a role in the most significant criminal and national security threats our nation faces. Now, of course, that's true also of the banking system. It's nothing unique to crypto. And so I think we've gotten to a place where DOJ is treating the movement of cryptocurrency the way it would, fiat currency through a financial, a centralized financial system. And that's actually a really fantastic place to be for this burgeoning industry. Now, this gets to some basics on kind of, privacy versus law enforcement access. And when we talk about privacy in this context, what law enforcement cares about is its access, of course, right? It doesn't care about, hiding, obscuring information from anyone else, from corporations. It just cares about its own access to that in the context of criminal investigations. Now, on the flip side, obviously, a lot of users care deeply about protecting their information from the government, and that includes a set of people who are intending to commit crimes, and that's why they want privacy, and then other people who simply don't trust the government or value their privacy. And you've got this tension, and you've got from the government's perspective some features that allow it insight or transparency for the purpose of evaluating and investigating criminal conduct with the use of Bitcoin or other cryptocurrencies. And then you've got things that make it more difficult. And this is a really general a summary, and it doesn't include some of the sort of more experimental or cutting edge technologies, because honestly, DOJ isn't even there in terms of considering those. But of course, you've got the public blockchain, which does provide a fantastic amount of insight to everyone. On the other hand, it's pseudonymous. I can never pronounce that. Sorry, guys. Right. So you can see the transaction, but not the individual. Now, on the other side, so going back to transparency, the U.S. government does have access to records that are in possession of U.S. money services businesses, so processors and exchangers. That helps to mediate, from the government's perspective, the pseudonymous nature of blockchain for anyone who is using those intermediary services, whether they realize it or not. You've got, though, mixers and tumblers where folks are intending to, obscure the source. You've got privacy coins, and then, of course, you've got level 2 protocols. Those are things that I think, though I haven't been in the government, within the last year, I suspect that the government is really still trying to work through how it's going to adapt its protocols to deal with. And then, the government still has this search warrant authority. How does that play, into this? Well, I saw a case recently in DC where the government got a search warrant to seize computers by an individual and search those computers for the private keys for the individual's cryptocurrency wallet. So that's almost sort of like an analog authority that allows the government access under certain circumstances to what would otherwise be particularly private information. So on the note of search warrants, I think this is to me a pretty interesting question, and maybe a new front in the sort of the tension between privacy and law enforcement needs in the context of cryptocurrency. So the question in terms of, let me step back. The Fourth Amendment guarantees basically the right against unreasonable search and seizure, and also it requires issuance of a warrant supported by probable cause in order to effectuate a seizure or a search. So the real question in terms of is whether the Fourth Amendment applies is whether there's a reasonable expectation of privacy. So folks have a reasonable expectation of privacy in their home, on their physical person, but then it becomes a little bit more challenging where individuals share that information with a third party. And so early on, there was a question presented, what about bank records? Do people have an expectation of privacy in their bank records because they share that information with a third party, that's a bank? And certain people argued, yeah, they do, because that's so private. But the Supreme Court in about, I believe it was 1976, says no, there is no reasonable expectation of privacy in your bank records because you voluntarily disclose that information to a third party, the bank. And the court also, I think, took something from the fact that they believed that bank records were more like a negotiable instrument rather than a communication. Now, you could agree or disagree with that, but I think it helped shape the way that in the United States, law enforcement and courts view privacy when it is balanced against the need for law enforcement to investigate. After that, you've got phone logs, trap and trace. So a pen register which records the phone numbers that are dialed from a phone. And the Supreme Court said, do you have a reasonable expectation there? No, you don't. And this I think is interesting because it shows the way that history shapes how these questions are answered. So I would imagine, this is, I think, back in the 70s, there were a whole bunch of old men on the Supreme Court, and I imagine they actually remembered a time when, in order to connect a call, you had to speak to an actual operator. And so one imagines that's why they would think, well, you don't have a reasonable expectation because everybody knows that when you call, you're conveying your information to an outside company. Nowadays, of course, that's not what people think with cell phones. But at that time, I'm sure that's what those 9 justices had in their heads and said, no, you don't have a reasonable expectation. And now that's the law with respect to cell phone logs as well. Now, what about cell site data? This was a very recent case and opened a whole new front in terms of challenging the government's incursion into private areas without a search warrant. The question was whether individuals had a reasonable expectation of privacy in their cell site data, right? The government didn't want to have to get warrants in order to get that information, just wanted to get it by issuing a subpoena. And the Supreme Court said, well, yes, actually, notwithstanding that people don't have a reasonable expectation of privacy in their bank records or their phone log, they do have it in their cell site data. Why? Number one, because it's not particularly voluntary to turn that information over. The Supreme Court thought, well, everyone has to have a cell phone. Everyone uses it. No one thinks about it. And the Supreme Court also thought it was important that the information was very personal. They called it an all-encompassing record of the holder's whereabouts that provides an intimate window into a person's life. And of course, I think we all understand that really makes sense. If the government has access to everywhere you've been at any time, I mean, that's a whole lot of information. Now, what does that mean for cryptocurrency records? Because on the one hand, you might say, well, people do have an expectation of privacy because that is what they understand cryptocurrency to provide. Now, that will obviously depend on the type of coin at issue, but at least provisionally, the one circuit court that is, the one court beneath the Supreme Court that addressed this question: do individuals have a reasonable expectation of privacy into basically, I believe they were Coinbase records. The Fifth Circuit said no. The Fifth Circuit said, you know what? Those records, those Coinbase records, those processor records, they're more like bank data than they are like cell site data. And they said partly that's because the record holder, Coinbase, was subject to the Bank Secrecy Act, had an obligation to record and report that information under certain circumstances. And they also noted, well, individuals can choose not to use an intermediary. That was one of the bases for saying people don't have an expectation, that it's voluntary to give your information to an exchanger or a processor. It's hard to see how this, hard to predict how this plays out. I don't think this is going to be the only case out there. And there's obviously, it's a potential new front for challenge because people's expectations are always changing, and the degree to which people can or cannot choose to forgo an intermediary is always changing. Now, speaking of the Bank Secrecy Act, which is one of the reasons that the Fifth Circuit said, nobody has a reasonable expectation in their Coinbase data. The Bank Secrecy Act, I think it's a funny term because, in Switzerland, bank secrecy means secrecy. In the United States, I think it's a little bit ironic. Bank Secrecy Act really means transparency, anti-secrecy, at least with respect to law enforcement. Financial institutions that are subject to the Bank Secrecy Act have to actually disclose things to the government. They have to keep records so that, one example, the travel rule, which I know is very controversial, requires financial institutions to keep identifying information of wire transfers. And it also requires them to actually file reports on suspicious activity. And so, financial institutions, that includes money transmitters in the cryptocurrency sphere. Now, the scope of the Bank Secrecy Act and what it requires and who it applies to, that's outside the scope of today's talk. But I think it's really I mention it because I think it's an important sort of framing for what the government is thinking in terms of the expectations. From the government's perspective, this is the stick they have. As long as an intermediary is used, and FinCEN does, interpret money transmitter, pretty broadly. So a lot of intermediaries in this space are going to be subject to the Bank Secrecy Act. From the government's perspective, that means that's data that it can have, and it will not need a warrant for. And it also, from the government's perspective, for good or for bad, from their perspective, means there's not an expectation of privacy in those records. Now, what about mixers and tumblers? I'm going back to the DOJ's cryptocurrency enforcement framework, and this is a direct snippet, a quote from that framework, in which the DOJ says, in addition to facing BSA liability for failing to register, conduct AML procedures, collect customer information, it says operators of mixers and tumblers can be criminally liable for money laundering because mixers and tumblers are designed specifically to conceal or disguise the nature, location, source, ownership, or control of a financial transaction. That last quote is actually from the U.S. criminal money laundering statute. Now, from my perspective, that statement is broader than is actually true. In order to commit money laundering, the individual or company actually has to know that what it's moving, the money that it's moving, the crypto it's moving, is the proceeds of criminal conduct. But that can be proven through basically what we call willful blindness. That is, for example, if there's advertising having to do with darknet type transactions. I share this though because you can see very clearly that the Department of Justice takes a very dim view of mixers and tumblers precisely because they are specifically designed to conceal or disguise the nature or ownership or other information about a transaction. And then this is my final slide. I just want to conclude with what I think is sort of a way to understand the US government's perspective on privacy, linking this back to mixers and tumblers. Mixers and tumblers are intended to be anonymity enhancing. That is their purpose. And the federal government takes a very dim view of that. On the other hand, there are some things, some technologies, some features that may have privacy as a side effect, but are not intended to have that. And so, probably the overlap between these two spheres is much larger than indicated, right? Because it's not always one or the other. But I think mixers and tumblers, that the purpose is to obscure the source, the provenance of the funds. So that's probably very clearly going to fall within the privacy as intended purpose, and that's, I think, explains why DOJ takes a very dim view of it. Something like the Lightning Network, I don't know DOJ's current position on that, but there are arguments to be made that privacy may just be the side effect of that. That the purpose of that is scalability. And so I think with respect to those types of technologies, protocols, et cetera, I think there's a lot more room for the government to accommodate because they're not seeing it as the purpose. And the reason the government is going to be suspicious of something as the purpose is that they don't see that someone not engaging in criminal conduct would be so motivated to hide their transactions from the government. That's just the bottom line. They don't. The other reason that that explains this framework is that when privacy is a side effect, the government can take measures, or even though the private sector can take measures to overcome that privacy, so that the government can get the insight it needs in cases like child pornography, which nobody really wants that to run rampant, of course. So, for example, Bitcoin itself, in the beginning, the government probably thought, people are engaging in Bitcoin transactions to hide crimes. Eventually, they came to see, no, there are so many wonderful, legitimate reasons that people are engaging in this, and that privacy, although desirable by some, is in some sense just a side effect. And I think that's why we're seeing the government be very pro cryptocurrency, where something has its intended purpose as privacy. It's going to be a constant arms race, right? So the government is going to be trying to find ways to get that information at the same time that the technology is trying to find ways to keep the government out. And same with data analytics, right? To the extent that the government can use data analytics to overcome some of the privacy side effects and get what it needs in criminal investigations, I think the government will be brought along with new technology. But where privacy is the intended purpose, I think there's always going to be an arms race. Technology is going to try to make incursions to get that information, and technology is going to, on the other side, try to develop to combat that. I think that's sort of, for better or for worse, is I think where we see the government kind of viewing privacy in the context of cryptocurrency and financial crime. And on that, I think I'm out of time, and I will thank you all for listening.
Hey, Kyle, this was fantastic. Thanks so much. We're going to transition to our next session now. Thanks again.
Thanks.